All right, welcome back from lunchtime. I hope everybody's full and has a full belly. Now the problem is everybody's going to want to go to sleep. Um, so let's keep moving on and talk a little bit about forms of ownership or different types of ownership. And I think it's important you guys understand this because this is actually going to be reflected on the title work and how title is actually given. Okay. So this is going to involve you guys in there a lot and because when the title gets ordered, you're going to need to know how they're going to take title. And there's three different ways you can take title, and one of them we'll just touch on. I don't even think I have a slide on it, so we might leave that out. Is we're going to talk about in some form of sole ownership, um, some form of co-ownership, and there's a couple of those we want to talk. Then the third form that we probably won't touch on is in a corporate name or trust. Okay. So I think that may be a little advanced. Probably won't touch on it here. So let's talk about the first way to take ownership is a single person. All right. Now, I know the people in real estate class love this, and you guys are going to love it too. The word for sole ownership is called severalty. All right. When one person conveys property or transfers it to a single person, they transfer it in the term of severalty, which sounds like several meaning many, but that's not what it really means, right? All right. What it really means is to sever or cut off from the rest of the population by being the sole owner to this property. So if someone owns the property singly, it's in severalty. So in severalty is the pronounced, right? Yeah, Zeke, question? No, 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 no. Question was married people can single. Are married people buy them individually? No, married people couples don't buy properties individually, and we're going to get into some of the laws. We'll talk about it. I'm talking about like like you. Are you married? You're not married yet. You're way too young to be married. All right. So if you went out and bought property right now, you'd buy it in severalty. Okay. Whereas I'm married, when I buy property, I would buy it in a different form, but not severalty. All right. Now, the second way that you can, and that's it, it's that simple, really. Got it? One person, severalty. Um, one thing to understand is corporations are considered a legal entity or a legal person. So, corporations, partnerships, LLCs all take property in severalty because they act as one person. Even though they may be ran by a board of directors and they may have a million shareholders that vote, the fact is Coca Cola Bottling Inc., my guess, is seen as one legal person. So when it buys a new bottling plant, it buys it as sole ownership or in severalty. Okay. Now, the second form of ownership is some form of co ownership, multiple people. Now, there are many ways to do multiple people, and this is going to be inherently what you guys are going to have to ask when you get an order. How do we take property? Okay. Now, in Indiana, what's the common way if if I was to call you, Cindy, and said, "Hey, I need an order," and I've got Bob and Mary Jones buying the property, without saying anything, the common way is we take this in some form of joint tenants. All right, tenants in common also is a way of multiple owners. However, tenants in common is not the common way, and you'll see why here as I understand. When a tenant in common, it's two or more individuals. It can be two, five, seven, nine, however, okay? Now, tenants in common, I want you to think of tenants in common like a pie. All right. Now, people give me a hard time about always talking about like a pie because it's food and I'm a fat man. That's not it. I'm not a big pie eater. I'd rather have a second piece of fried chicken than sweets. but that's neither here nor there. So here's the key. Think of tenants in common like a piece of pie, because I can cut a section of a pie and lift it out and put another section back in without really disturbing the general overall look of the pie. That's why I say that. And you'll see here in a minute when I talk about that. So, a tenant in common, the only thing they have in common is being a tenant, i.e., possession. So, possession is the only thing they have in common. Okay, right here in this classroom, there are 12 office suites. If all 12 of us owned this property, the only thing that we have in common or have to have in common is that we all have a possession. We all could own what's called an undivided interest. Undivided interest means I cannot take my section of the toys and leave. Okay? So, okay, real quick, what do we got here? Bob, Cindy, David, Mary, Zeke, Gwen, Alicia, Thomas. Was it 2, 4, 6, 8, 9 of you guys right now? Plus me is 10. So let's say all 10 of us go in and buy this room. We do not, listen to what I'm saying, and for you at home, make sure you understand that. We do not have to have equal interests. Okay? I could own 20%. David could own 5%. Gwen, you own 20%. Jose, you own 30%. All right? So that you can have what they call disproportional shares. Everybody got that? It's pretty simple. We are allowed to have disproportional shares. And we would put in accordingly. So, like if it was $1 million for this room, and I wanted 20%, I would put in 20% of the $1 million, or I'd give the 200,000. You know, somebody, what do we say, Cindy, 3%, you'd give the 30 grand. All right, so you would own 3%. We are allowed to do that. Now, here's the key. It's an undivided interest. What I mean by that is I cannot look at these, well, let's do easy math, 20 chairs and say, well, I own 30%, so I am taking these 6 chairs, and for those of you that don't have your calculator out, 30% of 20 is 6. Okay, so that's where the number comes in. I cannot say these 6 chairs are mine, those 2 chairs are Zeke's, those 1 chair is Jose's. No, it's an undividable interest. So I own 30% of every chair. I own 30% of every table. Alicia owns 20% of every chair. Zeke owns 3% of every chair. You cannot divide them out. They're disproportional interests, but they're also undividable interests. The only thing that we have in common is the right to be in the property. That's called possession. We also would have different title. That's why it's important for you guys to understand this. I would have title work on my interest of the property. So when you're taking this sales intake on your intake form, your title work is going to say Raymond Modulin as 20% owner in the property located at 12 Smith Street. Okay, so I have my own title work. Zeke's may say Zeke as 3% owner in the property located at 12 Smith Street. So we all have our own title work as well. Now, let's go back to the pie. Because each little piece is seen as its own title and all of that, I can treat my 20% just like I treat a house. I can sell it, I can give it away, I can put it in the will, I can do whatever I want to do, and I don't necessarily need to ask the other 9 of you guys for permission. Now, we probably made an agreement where we did, yeah, that's all fine and dandy, but under the definition of tenants in common, I can lift my section of pie out and sell it to someone down the street, and they would come in and we would do a sale, and you guys would have a sale, but on the title, instead of staying 12 Smith Street, it would say new buyer as 20% owner in the property located at 12 Smith Street. You see what I'm saying? He would have his own title work for his 20% of an undivided interest. That's how it works. That's why I say look at it like a pie, because you can lift a section out, put a new section in. I can will it away. I can give it away. When I die, it can go in my go to my heirs. I can sell it. I can sell it to one of you nine. I can do however I want to do it, because it is the only thing we share is tenants in common. Okay. Now, contrast that with joint tenancy. And this is how we take property. If we don't specify, this is how we take property, because that way we think about it, guys. If we sold the property to 5 people as tenants in common, the title company would have to create 5 separate title works, one for person 1 at 20%, one for person 2 at 8%, one for person. So if you generally just say, hey, my wife and I are buying this property, it's a joint tenant. Joint tenancy, I want you to think of like a glass of water. Okay? What I mean by that is you cannot take a section out without messing all of it up. All right? So joint tenancy has also some other things that require. Now, let's go back. On tenants in common, Jose, what was the only thing they had to have in common? Right, tenants. In joint tenancy, you have to have 4 items in common, and they spell out PIT, P-I-T-T. All right, PIT. What those stand for is an anagram for 4 items. First one's P is possession. Same thing with tenants in common, had to have possession. Joint tenants, we had to have possession too. We also have to have the I, which is interest. Okay. Now, we cannot own disproportional shares. We have to own equal shares. That's the rule. So, 9 of you and me, that's 10. There's 10 of us. We would all own 10%, right? Everybody can do that math, hopefully. 10%, 100 divided by 10 is 10%. We had 5 of us, we'd all own 20%. If you have 4, you own 25%. We are not allowed to have disproportional shares under joint tenancy. Our interest has to be the same. And the interest means the interest amount, our interest ownership, the percent that we have to have has to be the same. Okay. Now, it still is an undividable interest, but not disproportional. Alicia, come on, you got a license? No, they're not. They're not the same. Okay, hold on. Home listeners wanted to know. She asked me. She said she thought disproportional and undivided are the same thing. No, no, no. It's 2 different types. Disproportional refers to the amount that we own. Undividable means we cannot segregate it out. So, for instance, go back to tenants in common. We are, and I'm shaking my head yes for those of you at home, we are allowed to have disproportional shares with an undivided interest. Okay? Shaking my head yes still. Disproportional shares. In joint tenancy, we are not, I'm shaking my head no, not allowed to have disproportional shares. However, they are still undivided. So, 10 of us in this room all would own 10% of the property. That does not mean I can take 2 of the 20 chairs and say, these 2 are mine, those 2 are yours, those 2 are hers, Zeke, those are yours, Gwen, you get that one and that one. No, I own 20% of all the chairs. You own 20% of all the chairs. They own 20% of all the chairs. So it's an equal interest, but still undividable. Okay. Um, so you've got possession, you've got interest. The last one, the third T, or the first T, third letter, is title. We all would be on one title. Okay, remember earlier I told you that it would say Raymond Modular is 20% owner located in the property at so and so, so and so. Now, what it would say is owners Raymond, Bob, Cindy, David, Mary, Zeke, Gwen, Alicia, Thomas, Jose as owners of the property. And it's one title work that names all of our names. That's why it's important for you guys to know when you're making a sale, how are they taking title? Because if they're taking it as joint tenants, it's going to be one title work process. If they're taking it as tenants in common, you may have to write 10 different title policies and 10 different deeds so that each one of us can have our own title in tenants in common. All right, you understand what I'm saying? All right, good. Because joint tenants is one title. The third thing, or the fourth thing, is time. Time. We all have to get it at the same time. Okay? Typically, it's an act of law, like a reading of a will. So let me give you an example that I love. 4 grandsons inherit the farm when their grandfather buys the farm. Oh, come on. That's funny. I don't care what you say. Nobody got that? Nah, maybe I'm the only old one in here. So grandpa dies. That's what they call buying the farm. Nobody heard that? No farmers? Okay, never mind. Grandpa dies, leaves the 4 boys the farm as joint tenants. So they all got it at the same time. All right. They all get possession to be on the farm and work it. They all have the same interest, which is how much? I really need to learn to turn my phone off, I guess. How much interest do they have? That's right. 4 of them, they each get 25% interest. And they all go on their one title. So it's got Jerry Jim Bob, Jeffy Jim Bob, Johnny Jim Bob, and June Jim Bob. I don't know what that is, but you get the point. All 4 of them as owners to the property of so and so, so and so. Okay, that's what joint tenants mean. Now, because they got it all at the same time, now we're going to bring in this other thing that joint tenants have, and by definition is required in a joint tenants. Okay, and a lot of times you'll see this as JTW. ROS, joint tenants with right of survivorship, JTWRS. I don't know if the O's in there. Sometimes it says JTWRS, joint tenants with right of survivorship. Okay? What that means is this. Let's go back to the 4 boys that inherited the farm. When one of them die, the other 3 inherit his portion equally amongst themselves. So there were 4 of them. How much interest do they own? Somebody, right? 25%. One of them dies. His portion gets divided. Now what do they own? There's only 3 of them left. Right. They all own 33 1/3%. That's 100. Now the next one dies. What do they own? 50-50. Very good. I love the simple math. And then the last one dies, and you're left with A, or June Jim Bob, as the last one. He wins the game, so to speak. He's the last surviving brother of the 4. He now owns it in 100% by himself, which is called what? Bob. Bob's like not making eye contact because if I don't look at him, he won't call me. What's it called when he owns it? One person owns it? That's right, severalty. So the winner, yay, owns it. Now he can do with it what he wants. Now, what that means is this: because the surviving brothers get the portion of the one that just passed away, he is not allowed to give it in his will. He can't sell it. He can't give it away because joint tenants mean with right of survivorship. When one person dies, the other person gets their property. Okay? That's all it means. So when the fourth brother got sick and before he passed away, he can't will it to his kids because joint tenants mean right of survivorship. When the tenant dies, his interest passes to the remaining uh, person. Okay. Now, right down here on the thing, it says while the joint tenant is alive, he or she can transfer interest to another property. Um, there is a very special court case where they can actually go and get their section cut out. All right, it's called partitioning, and that's what this means down here. When a joint tenant is alive, let's say one of the four brothers was the black sheep of the family and doesn't want to be involved and wants to collect his, so he can actually go through a court case called partitioning. It's right there, right? Might run right there in your notes. Partitioning, which will allow him to then sell his 25% outside of the um, group. Okay, Jose, go ahead. Sure. What? Uh-huh. Well, yeah, no. Part. Yeah. Okay. Let me back up here. What I'm telling you is information that is factual. Probably is not going. What Jose said for you at home was, can he sell it to the other brothers? The answer is yes. He most certainly can, and probably would not have to go through the partitioning if he did it that way. He would just approach the other three and say, I want out. They all would kick in a little money and they would then split his share amongst the three. Um, but he most certainly could partition and sell. Um, Partitioning is really hard. It's a very hard court case. Although I'm not a practicing attorney, I did sleep on a Holiday Inn Express last night. But I can't. Uh, that was supposed to be humorous. I don't know. Maybe I'm losing my touch here. Um, it can be done. It's just hard. Okay. Now, with that being said, once that guy partitions his 25% out, he can never come back in as a joint tenant. The other three, so let's assume letter D, there's four boys, and they named their boys A, B, C, and D. Much easier to keep track of than the other four that we talked about. So A, B, C all stay in, but D is the black sheep. He partitions his portion out. He then sells it to their cousin who happens to be named, guess? That's right, E. Makes it really simple in your head. He could sell it to E. Now E comes in, but guess what? E's got his own title work because now he owns 25%. So what I'm telling you is A, B, and C still continue to operate like joint tenants, but together the group of those three are a tenant in common with E because E will never change. Go back to A, B, and C. How much do they own? They each own 25% because they were three of the original four, right? Got it? Now, A dies. A dies. His portion gets split amongst the remaining two. But remember, they now only own 75% because D sold out. So A dies. That leaves B and C each with half of 75%. So they now own 37.5%. I'll wait for you to do the math if you'd like, but trust me, okay? But E still only owns 25%. So now we have disproportionate shares, and we have a different time it happened, and we have disproportional the interest portion. We have a different time it happened because E bought his after the four did, and they're on different title. The only thing they're sharing is what? Okay. The only thing they're sharing is what? Right, David. The only thing they're sharing is possession, which by definition is tenants in common. So A, B, and C are still joint tenants and they still work with the right of survivorship. The only difference is together that group is a tenant in common with E. All right. Now, there's a very special type of tenants in common for married people. It's called tenants by the entirety. Tenants by the entirety. This is where both parties own the property 100%. So 100% plus 100% is 200%. That's not true. Tell you what, I'm going to pause the recording here and do the next one because I don't want to make each one too long. So hold on.